In this lecture, we shall discuss the composition of the Supreme Court of Ghana. The composition of the Supreme Court of Ghana. The composition of the Supreme Court of Ghana. Now, the first point to note is that under Article 126 of the Constitution of Ghana, it has been clearly stated that the Superior Court of Judicature shall comprise the Supreme Court, the Court of Appeal, and High Courts and Regional Tribunals. So at least we know for a fact that on the strength of Article 126 of the 1992 Constitution, that the Supreme Court forms part of the Superior Court of Judicature. Now, also, it is important to note that the Supreme Court is the highest court of the land. It is the apex court of the land. It is the final court of appeal of the land. When you appeal from the High Court to the Court of Appeal, you get to the Supreme Court and then you lose. You do not have a further right of appeal. So the Supreme Court forms part of the superior courts of judicature. Now, we have to find out that what is the composition of the Supreme Court? Now, if you look at Article 128 of the 1992 Constitution, it gives us an interesting provision. It gives us what the composition of the Supreme Court is. So Article 128 of the Constitution of Ghana reads as follows, and I quote, "The Supreme Court shall consist of the Chief Justice and not less than 9 other justices of the Supreme Court. The Supreme Court shall consist of the Chief Justice and not less than 9 other justices of the Supreme Court." It means that as far as the Supreme Court is concerned, its composition at all times must be the Chief Justice and not less than 9 other justices of the Supreme Court. In other words, including the Chief Justice, the minimum number of judges you must always have at the Supreme Court is 10, because it says the Chief Justice and not less than 9 other justices of the Supreme Court. So Article 128 plus 1 is interesting because it only gives the minimum number of justices who have to be at the Supreme Court. It does not give a maximum number of justices that must be at the Supreme Court. It only says that it must be the Chief Justice and not less than 9 other justices of the Supreme Court. And so what this means is that at every material time in Ghana, on the strength of Article 128 plus 1, the minimum number of justices you must have at the Supreme Court must always be pegged at the minimum of 10, because the Chief Justice himself is one of the Superior Court justices, is one of the Supreme Court justices, and there must be some 9 other justices. So the Chief Justice and not less than 9 other justices of the Supreme Court. So as a matter of fact, if any president acts according to Article 144 and appoints 50 Supreme Court justices, then such a conduct will be perfectly within the dictates of the Constitution. If the person appoints 20 or 30 Supreme Court justices, such an appointment would definitely be sanctioned By the Constitution, because the Constitution only pegs the minimum number of justices as the Chief Justice and not less than 9 other justices of the Supreme Court. Now that we know what the minimum number of justices of the Supreme Court must be, now that we know what the minimum number of justices of the Supreme Court must be, let's find out that when the Supreme Court is supposed to constitute itself for its work, what is the number of justices that must preside over cases? And we'll have our information under Article 128, Clause 2 of the 1992 Constitution of Ghana. And this is what the provision says, and I quote, "The Supreme Court shall be duly constituted for its work by not less than 5 Supreme Court justices, except as otherwise provided in Article 133 of the Constitution." It means that for the purpose of performing its work, it is 5 Supreme Court justices, at least 5 Supreme Court justices that would have to be constituted for purpose of hearing any case. That's why Article 128 Clause 2 says, "The Supreme Court shall be duly constituted for its work by not less than 5 Supreme Court justices." It is also important to note that over here, it is the minimum number that is given. It means that the Chief Justice, when he's empaneling for any case, can decide to appoint and panel 7 people, can decide to empanel 9 people. It is perfectly right because the Constitution says that the Supreme Court shall be duly constituted for its work by not less than 5. So long as the number is odd, we can actually have an empanelment of 7, of 9, of 11 to hear a Supreme Court matter. So the Supreme Court shall be duly constituted for its work by not less than 5 Supreme Court justices. So over the years, there's always some practice direction that the Chief Justice will give to show how he'll be empaneling the people, whether in maybe in constitutional matters, they are going to let 9 people sit. So, but all of that must operate within the confines of the Constitution. But as far as the Constitution is concerned, all we are saying is that for the purpose of performing its work, the Supreme Court shall be duly constituted by not less than 5 Supreme Court justices, except as otherwise provided under Article 133 of the Constitution. What does Article 133 of the 1992 Constitution say? Article 133 of the 1992 Constitution reads as follows, and I quote, "The Supreme Court may review any decision made or given by it on such grounds and subject to such conditions as may be prescribed by the rules of courts." The Supreme Court may review any decision made or given by it on such grounds and subject to such conditions as may be prescribed by the rules of courts. Now, I'm moving on to the provision that I'm particularly interested in as far as the composition is concerned. It is Article 133 Clause 2. It gives us the number of justices that must preside when the Supreme Court is hearing a case on review. Look at Article 133 Clause 2 of the 1992 Constitution. It says as follows, and I quote, "The Supreme Court, when reviewing its decisions under this article, shall be constituted by not less than 7 justices of the Supreme Court by not less than 7 justices of the Supreme Court. And so the Constitution says that for its work, it shall be minimum of 5. So if you, for example, have a case heard by 5 judges, and then after the 5 judges heard the case, you want to apply for a review, then we are saying that it must be not less than what? 7. Over the years, in review cases, they only add 2 more justices to come and add up to it. So if the ordinary bench was 7, then the review will be 9. If the ordinary bench was 9, then the review will be 12. But the Constitution says that when reviewing its decisions, the Supreme Court shall be constituted by not less than 7. And remember, we saw under Article 128 that for purpose of its work, then it should be not less than what? 5. So, apart from review where it must be minimum of 7, if you come to Article 128, at every time, it must be minimum of what? 5 justices who will be presiding over the case. Now, how do we appoint persons to the Supreme Court? What is the qualification of a person who seeks to be appointed to the Supreme Court? Article 128, Clause 4 of the 1992 Constitution. It said as follows, and I quote, "A person shall not be qualified for appointment as a justice of the Supreme Court. A person shall not be qualified for appointment as a justice of the Supreme Court unless he is of high moral character and proven integrity and is of not less than 15 years standing as a lawyer." A person shall not be qualified for appointment as a justice of the Supreme Court unless he is of high moral character and proven integrity and is of not less than 15 years standing as a lawyer. So if you want to be appointed to the Supreme Court by the dictates of the 1992 Constitution, specifically Article 128, you must be not less than 15 years standing as a lawyer. So the next thing that we have to find out that there are times when you get to the Supreme Court and you realize that there's only one justice of the Superior Court of the Supreme Court presiding. Only one justice. How is that possible? How is it possible for only one justice of the Supreme Court to preside when in fact Article 128 says that the Supreme Court shall be duly constituted for its work by not less than 5? And even in review, it says that when reviewing its decisions shall be constituted by not less than 7. How is it possible that we go to the Supreme Court every time and we find out that there's one justice presiding? How is it possible? How is it possible for just one justice of the Supreme Court to preside and hear a case? The answer is under Article 134 of the 1992 Constitution of Ghana. It says as follows, and I quote, "A single justice of the Supreme Court may exercise power vested in the Supreme Court, not involving the decision of the cause or matter before the Supreme Court." A single justice of the Supreme Court may exercise power vested in the Supreme Court, not involving the decision of the cause or matter before the Supreme Court. Let me explain this. There are some matters that may come that may not necessarily involve a decision on the cause or matter before the Supreme Court. And let me explain this. Let's say that you have filed an application for extension of time within which to file your written submissions at the Supreme Court. You have filed an application for extension of time to file your written submission. Now, this application that you are seeking for extension of time, it does not have that. If anybody determines that application and they grant it, they've only granted you the extension of time to file your written submissions. If they granted you extension of time to file your written submissions, it doesn't mean that they have determined the main matter, because the main matter will be determined after the full bench looks at the written submissions and gives a judgment. So there are some petty things that can come before a single justice of the Supreme Court. So whenever you see a single justice of the Supreme Court presiding, it means that they can only preside when what they are presiding over, it does not involve the decision of the cause or matter before the Supreme Court. So a single justice cannot deliver judgments for the Supreme Court. They can't deliver judgment because the judgment will be the determination of the cause or matter before the Supreme Court. Let's say that you were supposed to file your written submission within some number of days, and you haven't filed it within a number of days. That's one. Or let's say you filed an application, you filed an affidavit, you want to file a supplementary affidavit. It can go before a single justice because that's supplementary affidavit you intend to file. If you file it, if they give you the permission to file it, that permission they granted you to file it is not a decision on the cause or matter before the Supreme Court. Because it is after the supplementary affidavit has been filed. That is when the Supreme Court will now look at everything and now make a determination on the cause or matter before it. So whenever you see a single justice of the Supreme Court presiding, it is a very limited jurisdiction they have. Very, very limited. They can only decide questions that do not involve the decision of the cause or matter before the Supreme Court. But what if you appear before the single justice, they gave a decision, and you're not happy with it, and you want to appeal against it? What do? It says that except that in criminal matters, where that justice refuses or grants an application, a person affected by it is entitled to have the application determined by the Supreme Court, constituted by 3 justices of the Supreme Court. It means that in criminal matters, if let's say you apply for extension of time to file your written submission and it is refused by the single justice, you can repeat that application. And when you repeat it, it will be determined by 3 justices of the Supreme Court. So there can be a time when you can have a single justice presiding, and it's a very limited jurisdiction because they can only decide questions that do not involve the decision of the cause or matter before the Supreme Court. Very, very limited jurisdiction. And if that single justice refuses your application and you are dissatisfied, you can repeat it, and then 3 justices of the Supreme Court will be constituted to hear it. And also look at Article 134B. It says, in civil matters, any order, direction, or decision given may be varied, discharged, or reversed by the Supreme Court, constituted by 3 justices of the Supreme Court. It means that in a civil matter too, if they refuse the application to grant extension of time to file a written submission, you can repeat that application before, and then it will be determined by 3 justices of the Supreme Court. So all I'm saying is that under Article 128 of the Constitution, we are told that for the purpose of performing its work, the Supreme Court should be constituted by no less than 5 justices. But remember, we noted that under Article 133, that those who review, they are told that in hearing a review, then the Supreme Court must be constituted by no less than 7. So even though Article 128 says that for purpose of its work, it shall be no less than 5, for review, 133 tells us that it must be no less than what? 7. It doesn't end there. There are times when a single justice can preside. Where do you find that one? Article 134. And when can a single justice preside? The single justice can preside when what they are going to determine, it will not involve the decision of the main cause or matter before the Supreme Court. They can grant applications for extension of time to file written submission. They can grant applications for leave to file supplementary affidavit. When they grant those things, they are not determining the main matter before the Supreme Court. What if you are not happy with the decision given by the single justice? They are told that you can have it determined, you can repeat it, and it can be determined by 3 justices of the Supreme Court. So take note that under Article 128, there are times when, for purpose of its ordinary work, no less than 5. For review, no less than 7. There are times when a single justice can preside. The single justice presides. This a decision you want to vary, you repeat it before 3 justices of the Supreme Court. So by way of recap, what we are saying in this lecture is this: that the Supreme Court forms part of the Superior Court of Judicature, as mentioned under Article 126 of the Constitution. That the composition of the Supreme Court is the Chief Justice and no less than 9 other justices of the Supreme Court, meaning at every point in time, the minimum number of Supreme Court justices must have is 10, the Chief Justice and no less than 9. That for purpose of performing its work, the Supreme Court shall be duly constituted by no less than 5 Supreme Court justices, except as otherwise provided under Article 133, that says that in a review application, that one, it must be no less than 7 Supreme Court justices. But there are times when a single justice can preside. And Article 134, it can only preside when the decision they are going to give, it is not involving the decision of the cause of matter before the Supreme Court. If they're not happy with that decision, they can repeat it before the full bench. The final thing I want to point out is what we have under Article 128, Clause 3 of the Constitution. Who presides over Supreme Court sittings? Article 128, Clause 3 provides as follows, and I quote: "The Chief Justice shall preside at sittings of the Supreme Court, and in his absence, the most senior of the justices of the Supreme Court shall preside." Seniority counts at the Supreme Court. If you have to, for purpose of performing its work, and the CJ is a member of the panel, the Chief Justice shall preside at that sitting. But if the CJ is not part of the panel, then the most senior of the justices of the Supreme Court shall preside. So the Chief Justice shall preside at sittings of the Supreme Court, and in his absence, the most senior of the justices of the Supreme Court, as constituted, shall preside. What this means is that you can be a Chief Justice right now, but at the time that you are appointed, you're going to meet other justices who are even senior to you on the bench. Even though you may have been appointed one day and you're even one day on the bench, if they are presiding, you, the Chief Justice, you must preside, even though there are other people who are senior to you. But when in the CJ, you are not a member of the panel, then that's one. Other justices, the most senior justice of the Supreme Court shall preside. This is where we shall draw the curtains in our lecture in relation to the composition of the Supreme Court of Ghana. But remember what we saw under Article 128, Clause 4, that a person shall not be qualified for appointment as a justice of the Supreme Court unless he's of high moral character and proven integrity and is of not less than 15 years standing as a lawyer. This is where we shall draw the curtains on our lecture in relation to the composition of the Supreme Court of Ghana. Thank you.